protects liberty, most people would probably point to the Constitution's 27 amendments. There are those of us, however, who feel that the framers' greatest gift to American liberty was the separation of powers. Most relevant to our event today, the Constitution separates the power to charge citizens with violations of the law from the power to adjudicate those prosecutions. That's not the situation, however, in a number of agencies that populate the executive branch. And this is by congressional design. Commissioners in administrative agencies such as the Consumer Product Safety Commission, the National Labor Relations Board, and most relevant for our discussion today, the Federal Trade Commission, are empowered to choose which cases to pursue administratively, prosecute such cases internally before agency administrative law judges, and then hear the appeals of those cases as adjudicators. Such a process has existed for 100 years at the FTC under the Federal Trade Commission Act. The commissioners hear appeals from the FTC ALJ and have the statutory authority to review both the ALJ's factual and legal findings de novo. Until a decision in the McWane case earlier last month, it had been 19 years since the FTC prosecutors had lost a case before the FTC commissioners. This state of affairs has raised eyebrows, to say the least. We're honored to have us here today with us an attorney advisor for a sitting commissioner, along with 3 FTC alumni, all of whom have served in that particular position for then chairman at the time, to discuss the pluses and minuses of the commission's litigation process. Leading off today is David Balto, who is the founding partner of the law offices of David Balto. He has over 20 years of experience as an antitrust attorney in the private sector of the Antitrust Division of the Department of Justice and the Federal Trade Commission. From 1995 to 2001, he was the policy director of the Bureau of Competition at the FTC and attorney advisor to Chairman Robert Pitofsky. He is also responsible for our doing this program, kicking it off early last year, in the middle of the month in August. He authored a legal backgrounder for us that is available for those of you who are here, and we can send it to those of you who are online. The FTC at a crossroads, can it be both prosecutor and judge? Speaking second is Jan Rybnicek, who is an attorney advisor to Commissioner Joshua Wright of the Federal Trade Commission. Prior to joining the FTC, Mr. Rybnicek was an associate in the antitrust, competition, and trade practices at Freshfields, Brookhouse, Derringer in Washington, D.C. Third speaker today is Robert Davis, who's of counsel with the law firm Venable. Prior to joining the firm, Mr. Davis spent more than 10 years at the Federal Trade Commission. He was an attorney advisor to FTC Chairman Leibowitz from 2005 to 2011. He's a trial attorney on the Commission's administrative litigation against Rampus as well. And finishing up today is Andrea Marino, who's of counsel in the D.C. office of the law firm Wilson, Sonsini, Goodrich, and Rosati. Mr. Marino previously served as a counsel to the Assistant Attorney General of DOJ's Antitrust Division and as attorney advisor to FTC Chairman William Kovacic. We're also proud that she is the featured expert contributor on WLS Blog, the Legal Pulse on FTC matters. David, if you could get us started.
Thanks so much, Glenn, and thanks to the Washington Legal Foundation. Even though my stance on lots of issues are different than Glenn's and WLF, they do a terrific job in providing an avenue for a lively debate and discussion that really helps balance and helps progress thought, and especially in the competition area. I became interested in the FTC administrative litigation process, not only as somebody within the agency, but somebody outside the agency. I think it's important to see the critical role of FTC administrative litigation, some of the crucial decisions of the some of the landmark decisions in antitrust over the past several decades, cases like Indiana Federation of Dentists, Hospital Corporation America, and Toys R Us, were cases that arose in FTC administrative litigation. And the reason why administrative litigation is important is because Congress envisioned the FTC to serve as an expert agency, bringing together commissioners who, through both studies and through investigations, would really be able to articulate important standards of the law. It's important to contrast with that with federal court litigation, which takes a tremendous amount of time. All you have to do is look at the Justice Department American Express case, which is still in its preliminary stages 4 years after it's been brought. Thanks to the reforms both in the Clinton administration and the second Bush administration, FTC administrative litigation has changed dramatically. There are strict time limits on FTC administrative litigation, so it's really fundamentally become the rocket docket of antitrust litigation. You can get an antitrust case done much quicker before the FTC than any place else. But here's the problem. The commissioners who vote out a complaint, very likely within 2 years, less than 2 years of, in fact, only about a year and a half after they voted out a complaint, are going to sit on a bench and make a decision as the ultimate tribunal. And how can a commissioner, and how can a commissioner who so recently voted out a complaint go in an impartial manner, go and make a decision about that complaint? Now, before the 1990s, this was less of a problem. Why? Because FTC administrative litigation proceeded at a glacial pace. It took years to go through the administrative process. A typical FTC case might take 3 or 4 years between the time a commission voted out a complaint and the time that a decision was made. And by that period of time, the commission may have changed. There may be different commissioners involved. When the FTC, when the ABA antitrust section looked at the problem of the FTC proceeding as both a prosecutor and judge, they said it's less of a problem. It may not be that significant of a problem because the composition of the commission may have changed. But that's changed dramatically because of the imposition of these time limits on the litigation process. Now, before the mid-1990s, you might have worried less about this problem because about 40% of the time that the commission voted out a complaint, it actually reversed itself. After that lengthy administrative litigation process, it said, wait, we didn't get it quite right. There wasn't a violation here. We're going to dismiss the case. But, as Glenn mentioned, from 1995 until January, in every single case, the FTC found a violation. Now, that doesn't mean they were calling balls and strikes right. In fact, during this Lance Armstrong period of success, approximately 20% of their cases actually were dismissed when they were appealed. And you compare that to general appeals of antitrust cases from district courts to courts of appeal, those are reversed about 7% of the time. In key cases like Schering and Rambus, the commission really went a little far in reversing ALJ decisions which found no violation. And you can really see, as you look at those decisions of the courts of appeal having a certain sense of unease that the actual decision maker, the person who heard the evidence, who saw the witnesses testify, was having their decision reversed. And in both of those cases, again, the courts of appeal reversed the decision of the full commission. Now, fortunately, this so-called Perry Mason type winning streak was reversed in the McQuain case. But why is this a problem? Well, I think first you have to look at it from the respondent's perspective. FTC administrative investigations last a very, very, very long period of time and are extraordinarily expensive. Now, if you're under investigation by the Department of Justice or the FTC, you see a very different process. If you're a respondent, you can ultimately make a decision that it may be worth it to go through this investigation process because if the Justice Department believes that there's a violation of law, you get to go before an Article III judge. Whereas if the case is before the FTC, the actual people who've investigated you, who voted out a complaint, are the persons who are going to be the initial decision maker. Now, you might say you still, under the FTC process, have a chance to appear before a federal judge. You can appeal the FTC's decision to the Court of Appeals, but that's a very narrow appeal, simply on legal issues. So there's a real difference between the Justice Department and the FTC process. Because of the expense of going through the FTC litigation process, the FTC is in a position to effectively coerce firms to settle cases. Most importantly, however, where there appears to be a lack of impartiality by the Commission, that really undermines the credibility of the process, and I think it makes it more difficult for the FTC to effectively litigate tough cases and get the Court of Appeals to support their decisions going forward. So that's my discussion of the problem, and I await hearing everybody else's solution to the problem that I've suggested.
Well, thanks, David. Let me start off by thanking Washington Legal Foundation for organizing the panel and for inviting me. I think it's a very interesting issue, and I've got a bunch of great panelists with incredible resumes, so I'll be interested in hearing everybody's thoughts. And David's obviously have been well documented. David's provided some background on the process at the FTC for administrative litigation and raised some important issues. What I think I want to do is briefly talk about some of the other literature out there that his contribution has added to that goes back some 50 years now, and make a case that the FTC should consider abandoning administrative litigation. So the first time I learned about this issue was after my first year of law school. I was an intern in BC for Jeff Schmidt, the bureau director at the time, and I think it might have been Rambus that was coming up or another case that had just gone through, and it just blew my mind that this was the process. As a young law student thinking about issues of fairness and what we expect out of the system, this didn't seem quite right. But it is the system we have, and it's been well documented now for, as I said, about 50 years. One of the first pieces on this issue was by Edgar Barton, a practitioner, who used some cases to demonstrate the possibility that there are issues of fairness arising from the FTC's dual role as judge and prosecutor. As David mentions in his piece, Commissioner Phil Ellman raised this issue again in a piece and observed from a position of experience as a commissioner that there are some issues that arise from putting two functions within the commission. He raised concerns about the commission being uneasy about reversing staff because of staff morale. He raised issues about whether a commission would be hesitant to dismiss a case that it had thought required some funding and investment and investigation. And so that was an important contribution. Richard Posner, then just a professor, did a empirical study on the issue a few years later as part of a larger piece on administrative agencies, in which he compared the FTC with the National Labor Relations Board, which actually at one point was similarly structured to the FTC, but then switched to kind of a function in which the general counsel took on the role of prosecutor and the board was then the adjudicated body. And the results from that, I think, are at best mixed, if not at some points kind of exonerate the commission. But again, those were using cases from the 30s, 40s, 50s, so maybe not as relevant today. And then fast forward a little bit, and you have folks like Doug Melamed, who in a comment to the Section 5 workshop raised the issue using some work from an associate of his, a colleague of his, studying cases through the 80s, 90s, and into the 2000s about the commission's win rate. And then Professor Josh Wright and Angela Dively did a piece, a bit of a tangent, but it was on the testing the expertise hypothesis, the notion that the FTC's authority should be expanded or is justified in part because of its expertise. And what they found there, based on reversals at the Court of Appeals and also just flat appeals numbers, was that the FTC actually is reversed more often than a generalist district court judge. David obviously has an important contribution to the literature, and I think coming out in August, Terry Calvani, a former acting chairman and commissioner, and Angela Dively again have a proposal in which, much like the NLRB, they ask for us to consider whether the adjudicative and prosecutorial functions should be severed. So based on this literature and the work that David's done, my view is the question is, what should we do? And I think the name of the panel here, the title of the panel is, should the FTC be judge and prosecutor? And I think an important question from that, or something that you have to answer first, is as compared to what? Well, I think at least in the short term, the relevant issue is as compared to a world in which it is just the judge versus, just a prosecutor and not also a judge. So when viewed in that kind of framework, I think the FTC should seriously consider potentially abandoning the administrative litigation process because the costs generally outweigh the benefits, and I'll explain that a little bit. David has identified a number of the costs, and the costs in part come from the issue of unfairness and the perception of unfairness. And maybe we should say at the outset that the folks at the FTC and the folks that I work with are all incredibly talented people with the utmost integrity. And what we're really talking about here is the institutional structure and how that takes expertise inputs and generates them into outputs. So I think we should make that clear at the very beginning. But some of the costs, as David has mentioned, is the perception of unfairness and what that means. I think that's an important point. It's not that it necessarily has to be unfair, but the perception is a big thing. Government employees, including at the Commission, are regularly recused from cases because of conflicts of interest. And I think 9 times out of 10, folks can probably put the conflicts aside and look at a case objectively. But those recusals are in place because of the appearance of unfairness. And I think that same issue applies here. So, and David has pointed out that in at least 2 cases that has been a problem for the Commission in achieving its mission. And that I think that mission is in enhancing consumer welfare through the development of competition law and policy. And in Rambus and in Sharing, the Court of Appeals, because of the FTC's institutional structure, kind of stopped it in its tracks in 2 very important cases, in a standard-setting case and in a reverse payment case. So I think that's a very big cost. Another cost is an issue that David also mentions is the consent issue, and the fact that a firm faced with the prospect of going through administrative litigation at the FTC may reasonably throw his hands up and say, I don't think I want to go through this process at which I might not get a fair shake or perceived fair shake until the Court of Appeals, and maybe it's better off for me just to settle this now at a lower cost. And I think there's potential for those consents to be not welfare maximizing for consumers. And there's also a third issue that is kind of internal to the Part 3 process. I think as David potentially mentioned, there's a forum shopping provision in the Part 3 rules or in the administrative litigation process that allows the defendants to, after the Commission rules, to then go seek an appeal in basically any Court of Appeals. Some have argued that actually strikes against the very purpose of the administrative litigation process, because it allows a defendant to then go to whatever Court of Appeals is the most favorable to it and kind of stops the development of competition law and policy in its tracks. And while I think a number of people would want to change that provision, we realistically can't, because it is the one provision that a lot of people see as the backstop that kind of creates a balance in the fairness and mitigates the perceived unfairness. And there are also costs unrelated to the unfairness issue. There's the cost, and I think we might touch upon this a little bit later, that essentially because of the wall that goes up after a complaint is voted out, you have a unelected, unappointed staff that is charged with litigating the case, and that power is taken away from the politically appointed commission. And there's also, I think those are the main issues. And let me get on to, you have to weigh those against, obviously, the benefits. And the benefits that David has mentioned and that we all hear about are that it is the ability for the issues to be litigated in front of an expert body and that they get to have the first say on how these issues, both consumer protection and competition for that matter, should be viewed. While I think the administrative litigation process is a unique function to the FTC, I don't think it's one of the attributes or characteristics that makes it what it is. I think those instead are things like its highly qualified staff of economists and attorneys, its ability to prepare reports on novel issues in the competition consumer protection sphere, its ability to collect data and prepare studies that inform how we think about these issues, and its ability, more importantly, to think about and offer persuasive arguments. And that's something that can be done in federal court as well as in administrative litigation. And it's something that the FTC does and does very well. Just think about the recent activist case in which the FTC was successful through federal court litigation to fundamentally change the way we think about reverse payments and bring them into a rule of reason framework versus think about them through the patent structure. One of the accolades of, I guess, administrative litigation is the recent, or not so recent anymore, but the Polygram Three Tenors case where Chairman Muris issued a very compelling commission opinion that was then more or less adopted by the D.C. Circuit. Now, I think that's an excellent example of the commission moving the law and getting what is the inherently suspect framework adopted by the D.C. Circuit. But I question whether or not that couldn't have been done just through filing of a brief. Throw Chairman Muris's name on the brief, throw his name on the opinion, I think you get the same result, because the thinking about how the issues should be reviewed and analyzed is what's important, not whether or not it was in a commission opinion or in a brief. So with all those things, I think that the costs greatly outweigh the benefits, and that the benefits we can get through regular federal court litigation. And for those reasons, I think that, maybe we're not there yet, but it's something that we should seriously think about whether or not we need the administrative litigation process as a matter of policy within the agency.
So, not sure how to operate this. First of all, thank you, Glenn and the Washington Legal Foundation for having me. I really appreciate the opportunity to talk about this stuff. So I'm going to be a little counterintuitive, I think. I think there are some potential problems given the current structure of the Part 3 rules. I don't think eliminating Part 3 evaluation is the way to go. I think the question is really when the commission makes a decision to issue a complaint, what are they committing to? I mean, are they committing to saying, this is something we think there's reason to believe that there's a problem, there's reason to believe that there's that there may have been a violation, we should send this to administrative litigation, find out what the facts are, and then consider the case in light of the record created in front of the ALJ? Or are they committing to stopping a problem that's harming consumers today that that needs to be stopped? And the difference here is that in the first case, the commission is keeping an open mind at the time they issue the complaint about whether to issue a complaint or not. In the second case, they're far more committed to stopping the problem before ever seeing the record. And I think right now, to a great extent, what the commission does is the latter, not the former. The commission spends a very long period of time deciding whether to issue a complaint, and the bigger the complaint, the bigger the case, the more time they spend, and not coincidentally, the longer the investigation at the beginning of the case as staff tries to dot all its I's and cross all its T's and answer all the commission questions. So I'm going to get back to this point in a minute. I'm going to talk a little bit about Rambus, because why not? I haven't talked about Rambus in a few years. And it was part of David's article, excellent article on this topic. So I actually think Rambus is a bad example for this topic, actually. I think for two reasons. First, it actually wasn't an example of a case where the commissioners who issued the complaint wrote the decision. In fact, I think all of the commissioners were different. Maybe Harbor was the same, but all of the other commissioners were different. The commissioners who voted out the complaint were long gone by the time the commission decision was issued. I can tell you that this was one of the longest cases at the commission in a long time. It actually broke the record for the longest transcript of all time. It wasn't the longest in time period. The trial actually was only about 2 months, but it happened every single day. So there were the old cases in the 60s and the 70s, I guess, where the commission would do you'd have trial 1 day a week, and then the thing would go on for years and years and years. And this case went on day after day after day for 2 months. And I actually was on the trial team. I have the honor of being one of the few lawyers who lost on my issue at every single level of review. Everybody else won sometime. It was sort of like everybody had an opportunity to win but me. And that's actually the second reason why this is, that's actually the second reason why this is a bad example, because I lost at every level of the thing. Actually, it is. That's actually my point. The decision, the issue that I was relying on, so Rambus was a standard-setting case. The allegation against the company was that they attended the standard-setting organization meetings and had patent applications that they thought covered the standard, and then didn't tell anybody in violation of what the staff alleged and the commission believed was the rule of the standard-setting organization requiring that they disclose these patents and patent applications, and then waited till the industry got locked in and then sued everybody. So the issue that I was focused on was the lock-in. So I'm an economist, lawyer type. So the first part of it was lock-in to the standard that was actually being decided, the first generation standard. But the more important issue for us was the second and third and follow-on generation standard. So why was the standard-setting organization, why was the industry locked in to the same technologies that were in the first standard years and years later? That's what I had to show. Well, at the ALJ level, we lost on those issues, but we lost on every issue at the ALJ. I'm pretty sure we would have lost on how to spell the name of the company if the company contested that. Of course, maybe we should have lost that issue. Who knows? But we lost on every issue. When we appealed to the commission, what staff won on was what the duty to disclose was. Did they have patent applications that covered the standard at the time that they were at the standard-setting meeting? Did they violate the rules by not disclosing them? And was the industry locked into the different standards as they happened? Well, the commission, we put on great evidence. This is definitely my fault, by the way. I'm not blaming anyone but myself. We put on great evidence about the first standard, but the evidence was different as to the second and the third generation standards. It more had to do with the standard-setting process than sort of hard economic facts. So we won with respect to the first generation standard, lost with respect to everything else. But by the time the commission issued its decision, the industry was already on the second generation standard. They were about to transition to the third generation standard. So as we saw it, as staff saw it, at the commission, we lost. We didn't win, we lost. Right? So the commission ruled against staff in a way that completely gutted any potential for a remedy in this case. The only thing that really happened for Rambus, and it was a significant issue for Rambus, was having lost at the first generation, for the first generation standard, they owed companies like Samsung and Hyundai a lot of money, and they had to fight that out with them in terms of the first generation standard, and that's what they won in the DC circuit. But as to what was going to happen in the market going forward, we lost at the commission. So, I mean, that makes me wonder about the statistics that say that the commission has won every single case for the last, 3,000 years. Because, frankly, when you look at it, you could actually argue in McWane as well. But the commission won in McWane. I mean, staff won in McWane, right? McWane got hit with monopolization and a few other things. They also lost, but they won in those. There's a lot of mixed cases. So, putting that aside, I think Rambus is not a particularly good case for that. Now, in terms of the solution to this problem, the problem is whether the commission, the commissioners issuing the complaint are the same people who are actually writing the decision, and how big of a problem is it? And I think David's right, and I think Jan is right, that it is actually something that's happening more. And it's happening more because of the Petofsky and Majoris and Kovacic reforms that happened to speed up the process, to make them go faster. It's now actually more likely, and it happens a lot, I think, that the commissioners who issue the complaint are the same ones that write the decisions. But I think the thing that needs to be done is actually, and here's where I get counterintuitive, is that the commission needs to issue more complaints. This is the problem. The commission spends way too much time thinking about the complaint, and this part of the process is the most structurally unfair to respondents in the entire process. And this process, by the way, is the same process as DOJ, right? Staff investigates, it's between staff and the respondent. Then they go to the decision maker, whoever that is, at the front office at DOJ, at the commission, it's the commissioners in the front office in the Bureau of Competition, and the respondent comes in and talks to the decision maker with staff sitting right there. Respondent leaves, and then staff gets to say, here's all the things that the respondent said that were just flat out lies. Here's all the things that they said that was wrong. There's no record. The respondent's gone. They can't argue about it. Then they leave, and it's lunchtime, and the commissioner goes up to the top of the trade, which is the cafeteria at the top of the FTC building, and sees one of the staffers who works on the case, and they spend some more time talking about the case. Right? They're allowed to. There's no Part 3 wall. This part of the process, which I don't think is very different at DOJ, and Andrea can correct me on this, is open-ended and very informal, and is one where the staff, which is really, they spend a long time thinking about this case. They want to talk about this case. Frankly, they're happy to have people disagree with them about the case. They just want something to happen with it. But they're part of the same agency as the commissioners are. They're part of the same agency that person who's running the agency is. And it's not a matter of even if it's just subconsciously, you're sort of on the same team, you're sort of talking. To the extent that that part of the process locks in the commissioners into a point of view about the case, that's where the problem is. So my recommendation is that the commission really, there's no reason for it. The commission's standard for deciding whether to issue a complaint is whether there's reason to believe a violation has occurred. And some commissioners, Commissioner Leary, I think, actually took that very seriously. He was like, give me reason to believe, I'll vote out the complaint, you guys prove your case. I may not agree with you even on the legal theory at the end, but just give me reason to believe, and then we'll move on. Because I don't want to get locked into thinking about, and I'm maybe putting some words in his mouth at the end. He agreed with me completely, but anyway, he probably had no idea what I was about to say. But that part of the thing, if the commission has that as its process, then the commissioners themselves, even when they see it afterwards, are not nearly as committed to the process, not nearly as committed to the facts that they think are true based on the conversations that have happened before the complaint was issued. And then they could focus on the record that was established between the parties and commission staff in front of an ALJ, according to the standards and the rules in the Part 3, rules of procedure. So you would have a much more even-handed, then the decision about what to do about the complaint gets decided based on a record that was put together in front of both parties. So that's my recommendation. I think to some extent, and we could talk about this more, just like an open question. The commission is, I think, starting with Patofsky, and it's true in Majoris and Kovacic that they've, I finally stopped saying we've, that's weird. They've focused on reforms that made the administrative process more similar to DOJ's process. And I think actually that might be a mistake. They need to think about the administrative process and improve the administrative process itself. It's sort of an application of the theory of the second best. Okay, right? If the first best, and I'm not necessarily agreeing with this, if the first best was that we should have the DOJ type process where we just go into court, I don't think the second best solution is to take the FTC process, which is an inherently administrative process, and try to make it look like the DOJ process, because there's too many things about the FTC process that make it impossible to make it like the DOJ process. The best way to do it, the second best solution here, is to make it the best FTC process you can have. And I think part of that is going to be focusing on getting out, also multiple complaints, getting out faster. You'd have more dismissals of complaints, right? The commission looks back at the complaint and says, man, we shouldn't have done that. And that's what the commission used to do. I think faster, more, and there'll be less commitment to the cases, and the cases will be done more fairly. So that's my recommendation.
Well, I will also add my thanks to Glenn and to WLF for hosting this panel today. As a student of Kovacic, I think institutional structures are just so important, and when you have the opportunity to talk with people like this and about these issues, I just think it really helps advance sort of not just what you do as an institutional matter, but also the policy discussion. So I'm really thrilled to be here. I guess I have many reactions about what we've heard from various people today, and I'll just give you a couple of them. You know, the first is I think we all agree that there really is a fundamental issue of fairness here that sort of offends our consciousness when you think that the person who's just investigated you is now the one who's doing the judging. And for, the entirety of our American system depends on having that comfort and that separation of powers that Glenn mentioned at the top of our discussion. So, it is clear to me that this is an area where I think there will be more disputes going forward and that where some solutions are really necessary. At kind of the tail end of my remarks, I think I'll offer a couple practical solutions. But, based on my experience having been at both the FTC and what I learned while I was at DOJ, I don't have the same sort of sense of fright about having these 5 commissioners or any of the 5 commissioners that will sit at the FTC going back and sort of reviewing their homework. Maybe in part it's a naive response, but I do believe that the commissioners are able to go back and revisit newly provided evidence and evidence that is just multiplied in detail exponentially. And I think they can go back and they can look and they can reflect themselves and say, did we do the right thing voting out this complaint? Now, in part, it goes back to a theme that Rob just mentioned, which is that these complaints are not indictments. They're not, suggestions that what people have done there's some sort of a real deep, unnecessarily unlawful action that has occurred. Instead, I think there needs to be more focus that what a complaint means is that there's reason to believe that a violation may have occurred. And so if you look at the complaints through that lens, then I think you free the commissioners a little bit to consider that some complaints may have stronger evidence than others. But what you really do is you start to train them to understand that what matters isn't what they put in the complaint, but what matters is the evidence that comes before the ALJ. And so if you get to the point where the ALJ is seeing, just volumes and terabytes of data and, testimony, that's what the commissioners need to be looking at. That's what their attorney advisors, frankly, need to be reading. It's not going back and reading the initial staff memos about this investigation. It's going back and seeing what is it that the parties actually proved before the ALJ. So if you instill some, in part additional discipline in that process, I think you'll find that the commissioners are more willing to go back and reverse themselves, whether it's the same people who voted out the complaint, in 2013 who'll be voting on an ALJ opinion in 2015. I think that is, it's a high obligation when people sit as commissioners of the Federal Trade Commission, and I think they take that extremely seriously. So I don't have sort of this fear that they will never vote against themselves. Now, I think that the 19-year win streak, that's what you'd say in response. Well, okay, hey, hotshot, the 19 years winning in a row is kind of, it's obvious they were ruling for themselves. But what I'll say is, I've been practicing since 2001, and I think there's been sort of a fundamental shift in the way the FTC looks at things. I think that, when I interned as, like Jan, I interned as a 1L at the FTC. And I remember one of my supervisors telling me the great thing about being at this agency is that you can exhaust every single aspect of discovery pre-complaint. So you can basically depose anybody you want. You can get any document you want. I don't think he may not have been right then, but I certainly don't think he's right today. I think the FTC, driven in part by what's happened over at its sister competitor agency, the DOJ, has decided to take a view that you don't need to know absolutely everything before you go ahead and file a complaint or make a recommendation. Practically, they can't. I mean, it's just impossible. In the span of, let's think about a regular second request. In the span of a second request, the parties will comply. The parties have gotten faster about providing documents. The parties have gotten better about building up their economic evidence. So they trigger that second 30-day clock where the FTC is forced to make an enforcement decision. Or whatever the date period is that the parties have agreed to once the second request substantial compliance has occurred. Nobody has the time anymore or the luxury to go through and do to look under every nook and cranny. So what that means is, I think you have instances where both agencies are bringing cases where there still is a lot to learn in discovery. And because of that, I think what you can count on is that once additional information is learned, that and then put before the ALJ, I think you can count on the commissioners to go back and want to look and make sure that, you know, whatever new evidence was uncovered and provided to the court now, not provided to staff, but provided to the court through the litigation proceeding, they need to look back at that. They need to understand what it is, and they're more willing to say to themselves, we learned something new. This affects how I think about the overall issues, so I'm going to be willing to, I would be willing to go ahead and essentially reverse myself. I think, you know, Rob and I have discussed this before as well. One other sort of dynamic that's going on here is that I think the Commission's just bringing fewer cases. So this 19-year, you know, to have such a huge win streak and is just, we're not really comparing apples to apples anymore, because there have been these procedural enhancements, both in terms of the technology, but also in terms of the strategy. And so I think you're just sort of dealing with a situation where things have evolved a little bit. Now, Jan, I think, offers an incredibly controversial suggestion, and very provocative and very interesting, most importantly. You know, I'm not ready to say that the FTC should abandon administrative litigation. Instead, I think they need to get smarter in several ways and be a little bit more open about why they're choosing administrative litigation. So, you know, this comes back to my practical solutions. I think the first thing the Commission really needs to do is explain why some cases get tracked to the ALJ without any federal court proceeding, and other cases get tracked into federal court proceedings. And then often with an ALJ component, that action is typically stayed as soon as they file it in federal court, pending resolution of federal court. But it was always, I don't know if Rob or Jan or David feel the same, but it was always a mystery to me why some cases went ALJ and other cases went both federal court and ALJ. And I think that it would serve the public very well for the agency to explain why that is the case, because the answer cannot be, we think we have a better chance of winning in our home court. That's not what you want to hear from a public agency. So I think that they should consider putting out guidelines or explaining themselves, frankly, about what makes them make that decision. The second thing I think they can do is actually make these ALJs antitrust experts. I don't know, you know, I should be a little circumspect here, because this was only information that was good as of when I left the FTC in 2009, but the ALJ is drawn from a pool of anybody applying to be an administrative law judge. And so that means it can be somebody over at the NLRB, it could be somebody at the Consumer Product Safety Commission, it can be any of the other myriad federal agencies that have ALJs. I think making the ALJ that sits at the FTC a dedicated position of someone who has antitrust experience, who spent their career focusing on those issues, will lead to, it can only be positive for everybody, but will lead to decisions at the ALJ level that more truly reflect the state of antitrust law today. And so I think that will streamline the process, and that will, I think, improve things as a whole. And the last thing I'd suggest, and I don't know that the FTC has to announce this, but, you know, when I was there, and there were several matters at the Commission before, on appeal from an ALJ, occasionally it would be a commissioner office that was drafting the opinion. I don't know if that's the way to go. You know, my sense is that the FTC has an amazing team in the Office of the General Counsel that are career lawyers who focused on antitrust issues for their entire career. And I think, or for their entire tenure at the FTC, I should say. And I think that more formalizing and having the opinion writing being written by somebody other than your attorney advisor may do things to make the opinion a little bit more objective, maybe take a little bit of a harsher look at what you see from staff, or what staff presented to the ALJ. Those in OGC typically don't have a lot of day-to-day interaction with the staff people. It's just kind of, they sit in a different building, they do different kinds of things. But I think that you know, having that kind of as a procedural improvement and asking the career staff in the OGC to be the ones that will author the opinion may end up leading to better opinions, and by better I mean, you know, opinions that better match the current state of antitrust law today. It doesn't necessarily mean they would lead to opinions where the commissioners are always ruling in favor of themselves.
So if I can start the commentary, and let me just respond on a couple things. First of all, just on the overall issue of fairness, I think it's important to look critically at administrative litigation. Lance Armstrong might like these odds, but this is like starting the Tour de France, at the second or third leg or something like that. When administrative litigation starts, the commission staff has exhaustively investigated the matter with process, and they begin a process. The administrative litigation, it has to be completed within 13 months. It creates a tremendous disadvantage to the respondents. And I think undermines the ultimate fairness of the process. Then, when that fairness process is done, you get to go and have you get to argue before the full commission. Now, anybody who attended the argument in McQuain could not have sort of said this was a fair umpire calling balls and strikes fairly. Certainly I think that the commission tried to reach the best decision possible, but in the oral argument there was, intense questioning of respondents' counsel and almost no questioning of complaint counsel. If one just walked in and listened to this argument, you would have had the perception that the commission had already made up its mind. And no wonder, they had just gone and spent this tremendous amount of time investigating the matter and then going through an adjudicative process that was so streamlined. I think there's a need. Some of the commissioners have been talking about the need for regulatory humility. I think there's a need for adjudicative humility. And in that adjudicative humility for the commission, it's important for this process to be as balanced and fair to allow respondents to fully develop their case. And then when facing argument, the commission should give due deference to the findings of the administrative law judge who actually heard the testimony of the witnesses. You're making these judgments of credibility, especially on issues such as conspiracy. Those are best, the ALJ, is the person who's actually looked into the witness's eyes, has heard the test of, that credibility. On Jan's, so there's a tremendous need for, I think, administrative, adjudicative humility here. And again, this doesn't disparage or criticize the actual intent of, well-intended, really committed public servants here. As to Jan's proposal, I want to add a couple facts that help him, and it really bothers me to actually help Jan on his proposal. I want you to know how much this pisses me off. But there are a couple of examples where the Justice Department has actually achieved more through federal court litigation than the FTC has achieved through administrative litigation. The two best examples are the Justice Department case against Visa and MasterCard in the 1990s, in which they litigated a full rule of reason case. Now, if anybody can tell me another full rule of reason case litigated involving horizontal restraints, I would be glad to know. But as far as I know, this is the one case that was effectively litigated, and they did find a violation. You look at the Justice Department case against Apple that was recently won before Judge Code. It shows the ability to go in federal court and establish key precedents, and those precedents, I think, are important going forward. Just to comment on the perception of unfairness and that Jan has pointed out, the first question that Chairman Ramirez faced in a recent antitrust oversight hearing was from Chairman Baucus, where he commented on the FTC's Perry Mason-like winning streak. I mean, obviously that kind of thing on the halls of Congress is remembered for a significant period of time. And then finally, in terms of the good scholarship in this area, I wanted to also note a great article by Nicole Durkin, a student of Professor Kovacic's in the George Washington Law Review that also addresses this area. I think the Commission needs to look critically internally at its own process. And I think what's really disquieting, for me at least, since I published this article, was attending the oral argument in McQuain, which certainly didn't sort of give off the impression of a truly fair and balanced process.
Further comments from any of our other speakers?
Well, let me I just want to, the appearance of a fair and balanced process. I've been in federal court. Last fall we were in trial, and I can tell you that there were times when I felt like the federal judge was not giving the appearance of a fair and balanced process. What matters, I think, is what ends up happening in the opinion and in the rigorous legal analysis that occurs. And so I remain convinced, and I think you read Ramirez and Brill and in the McWane opinion, and I think you can see that they really did struggle. They may have had ideas going into oral argument. They may have just decided that maybe they're having a bad day. I don't know, but I think you can really see that they weighed the evidence carefully. And I'm not always the biggest supporter of kind of the 5 commissioners and the decisions they make. I'm not just some kind of it's not necessarily my default position. But I do think they take this issue incredibly seriously, and I do think if they know they're revisiting the evidence, that is a responsibility they will not take lightly. So again, you can call it naive, you can say it's overly sanguine, but I do think that there's a real opportunity here for the commissioners to revisit themselves, but still judge themselves in an objective way.
Yeah, just a quick point, and if I hadn't said it at the beginning, I should say it now. That my views are my views only, despite my best efforts. They're my views only and not the commissioners or the commission's. And I want to echo Andrea's point there. I think the commissioners all received briefs on McWane as they do on other cases, so it'd be strange if they hadn't formulated some opinion about a case. So I don't really take offense to anybody having a particular view about a case going into oral argument. You see that, as Andrea mentioned, in federal court as well. A couple comments on Rob's point. I think what you said about the reasonability standards is very interesting and a good point. I would be concerned about kind of severing the tie between the commission and its staff in the kind of discussions that occur in the hallways and in the briefings, because I think that is how the expertise of the agency finds its way into the commissioners and into their ultimate decision whether to prosecute a case or how it adjudicates the case. But the 5 or 4 at this point commissioners are very talented, but the agency as itself is what has all the institutional advantages that I think Congress intended it to have. So I think it's important to have those, to be able to have those conversations. And then finally, and maybe this is one of the reasons why I think there's a better chance of us getting a solution through abandoning administrative litigation or considering it, is that I take David's point on the fact-finding issue and the fact that the commissioners sometimes don't adopt in full the ALJ's fact-finding. But I think that's an important constitutional and legal structure there. I don't think actually as a matter of law under the APA, the commission as a matter of policy can say whatever the ALJ says goes. I think they have to, under the APA, make their own independent assessment of the facts. And in some cases maybe that will be to that they view the facts a little bit differently.
Well, okay, so just two things real fast. The first on the respond to David's point on the fairness of fast cases. Having been, as a Part 3 litigator for staff, I actually I don't think there is any inherent unfairness of having the faster cases. In fact, I think, on balance, the faster cases are more fair to the respondents than the cases that were really, in the old days, the respondents lost by default because, they were in litigation forever and they tried to sell the company or something else was supposed to be happening and, they had this shadow cast over them. Private litigators are perfectly capable of dealing with a case inside of a year, and the fact that the commission's been investigating with process for a long period of time actually tends to get in the way more than it helps when it actually comes to litigating the case. And then just as a matter of fact, in the Rambis case, the testimony of witnesses was significant. There were, like I said, 2 months worth of testimony and a gajillion pages in the initial decision by the ALJ. But I can tell you that you could read through that decision, read through his findings of fact and conclusions of law, you'll find no factual determination based on his view of the credibility of witnesses. He just didn't do it. And ALJs just very, very, very rarely make determinations of fact based on believing one witness's determination over another. That may be happening a little bit more recently, but it's very, very rare. Most of the time, you're looking at documents and you're listening to economist testimony, which because you don't want to look in their eyes, you don't want to listen to that. So the witness credibility is actually a surprisingly small factor in most of the determinations. 99% of the facts are determined in antitrust cases on the documents.
To give our attendees an opportunity to ask questions if they'd like to, you're going to be handed a microphone to elevate your voice only for the benefit of our online audience. Questions? I guess I will ask one then. For those of us who are not as well versed in FTC process, you had been mentioning that there was a wall during some of the processes. What sort of safeguards exist within the commission to the extent that they can have them to prevent any sort of problems that you might have with conflicts of interest?
Sure. So once the commission issues the complaint, this Part 3 wall goes up, and the experience that I've had with the Part 3 wall is actually when we first started at the commission. When I first started in John's office, we were working on the CB&I decision, Chicago Bridge and I decision, which was a big merger, consummated deal, gigantic. Commission staff let it through. No one knew why, and we were trying. So it was like 2-to-1 merger in 4 markets, and we were trying to figure out, working on the decision, why it wasn't challenged as part of the HSR process. And we couldn't figure it out. And we tried to find the memos, and we couldn't find the memos. No one could remember, and we came up with this conclusion that, frankly, that the general counsel's office, who wouldn't tell us anything, walked around after the complaint was issued with those little flashy things from the Men in Black, and just like flashed everybody, and everybody forgot everything about the case. It is treated exceptionally seriously at the commission. It's a bright line. Once the commission has issued the complaint, you have 2 teams. You have the team working on the case, and you have the commission side. And at each level of the commission, the commission is broken up. You have people in compliance, you have people in the Bureau of Economics, you have people in the general counsel's office, and they're split into teams. And they don't talk to each other about the case. One side helps the commission, the other side helps staff. So that's what happens once the complaint issues, and it's a big pain in the neck, actually, when the parties want to talk settlement. But most of the time, it works very well to ensure fairness in terms of how the process works once the complaint is issued.
Yeah, if I could just add, the commission takes that wall very seriously. One of the interesting things about the breakup that you just mentioned is that nobody is helping the ALJ. The ALJ has a staff of, I'm not entirely sure, but it's not many. And so the expertise of the agency isn't getting funneled into the ALJ, and I'm not sure what the ALJ's budget is. Maybe David could help us, because I think you read the budget on your flight over. But so I think that's an interesting issue.
So do you think that some of the problems that might exist with this would be remedied if the ALJs did have more expertise at their disposal?
I don't think that's the crux of the issue to me. As I mentioned, I think it's the appearance of unfairness, not even necessarily whether or not there's actual unfairness. It's the perception of unfairness is kind of what has dogged this dual role of the FTC.
I want to emphasize, though, the unfairness of the actual administrative litigation process. Remember, the commission staff has investigated this matter probably for 2 or 3 years. They've got all their ducks in a row, and all of a sudden the game starts. You've got 13 months to get this done, and the respondents have to go from 0 to 60 miles an hour, or in just a very short period of time. It's very, very different than the litigation process in private litigation.
No.
I would take a different view. I don't think that the respondents sit on their hands during the. First of all, I don't know any cases being investigated for 2 or 3 years. I mean, there's some conduct investigations, I guess. My practice is more focused on mergers, and since those are driven by the Hart-Scott timing, we've complied with second requests in as little as 6 weeks. And so that means 30 days after that's the end of that 6th week, the FTC had to make a decision about what to do. I think respondents still have the opportunity to control the timeline. And I also think even in those conduct investigations, what I've seen is that respondents are putting in their arguments and are challenging the FTC on the FTC's arguments. They don't have the opportunity necessarily to depose the FTC economists the way they have to wait till that complaint comes out. But they can certainly go in and find out, tell us why you're thinking this. Principles of good government transparency have always, I think, counseled in favor of the FTC sharing that information with the parties. And so I don't think that the respondents have just been, sitting around waiting, hoping that no, the FTC is not going to file a complaint. I don't think there's anything fundamentally different when you compare it to the DOJ alternative, though, as well. During that process, everything is moving very similarly. It's in the end, the arbiter is going to be a judge, an Article III judge, or it's going to be an ALJ. But I think that the parties, I don't. When I think about the things that worry me about my clients and being treated fairly, this is not one of the things that strikes me as a concern. That somehow the FTC has gotten a head start on the investigation, and that we can't know what they know, because there are ways to do that. And I think that that's how it works. I mean, I don't know if Rob, you have the same view.
I
but.
mean, dealing with staff and learning the case is the most important part of the early part of the case. There may be differences for well-represented and not well-represented parties. It's not uncommon for companies to come to the commission with people who aren't experienced in the FTC process, who don't understand inside the Beltway antitrust law and agency practice, and they may be caught by surprise. But I think by and large, if a respondent is represented by counsel that knows what it's doing, there's no real disadvantage. I do want to add one thing on the ALJ point. Actually, it is important that they understand antitrust law. I think that's critical. But a lot of federal court judges don't really understand antitrust law. The real problem, actually, with the ALJs, to the extent that there is a problem, and there has been a problem in the past, is that they're not very experienced in the big cases. Managing and dealing with the big cases, we have a bunch of experts, tons of witnesses, people coming from all sides, questions of confidentiality that are complicated, timing issues, people coming from all over the world. Those are complex cases. To the extent that you got an ALJ whose experience is in front of the Social Security Administration, who's dealt with small cases all his career or her career, that's going to be probably the biggest problem in dealing with cases. And it is true, there are ALJs, there are agencies where the ALJs are specialized. And I remember when I was in John's office, we actually tried to get some language in a reauthorization bill that would actually give the FTC the ability to do this, and we never got it through because of other stuff that was in there. But the PTO, I think, and the tax court both have ALJs that are actually specialists. So part of the selection process for those two agencies is, what do you know about the practice area? So you could do it, you just don't do it yet.
I think the ITC does as well.
Yeah, that makes sense.
Andrea, you had mentioned that it's never really completely clear as to what motivates the commission to choose to go to administrative route or litigation route. Do you have any insights on that? Is it a staff-driven thing more than a commissioner-driven thing? Is it a type of commissioner who has more of an interest in litigating than going administrative? You don't have to name any names.
I honestly, I think maybe, I don't know. It baffled me. I remember in particular, with a merger I won't name, and when we were in the chairman's office, and when it got to us, there was kind of this, it was a fait accompli that we were definitely doing dual track, absolutely doing dual track. And then the next day something else came up, and they said, well, this is definitely ALJ, this is definitely ALJ. And I don't know. I don't know, Rob or Jan. You're more fresh. You have better insights on this.
I don't have an answer, but I can say, for example, take the activist case. It's a case that predates me, but having circuits like the 11th Circuit that ruled against the FTC in sharing on the same kind of issue, on the reverse payment issue, you go through ALJ or administrative litigation on that case. The defendants just appeal, and this is the forum shopping issue I discussed, defendants just appeal to the 11th Circuit and they win. So when you're faced with those kinds of problems, then you must go through federal litigation, and you must go to a district that might be more open-minded about the issue. So that's one factor, I think, in the decision.
Yeah, that's exactly what I was going to say. Is that the example that happens most often, that happened most often in the recent past, was the commission trying to find a way to find a split in the circuits. In other words, to get a case that didn't go to the 11th Circuit, find something else, 2nd Circuit, 9th Circuit, 4th Circuit, to try to get the case to the Supreme Court. So that was the only time I could think of. On the merger side, the only big change that's happened over the years is that the commission has gone from, I guess, David, always going into Part 3 after losing in front of a PI to not always to, I think right now it's almost never. We sort of moved to, when we were there, to like, you know, you lose, you know. There's very little chance that we thought, frankly, just in practical matter, we thought there was very little chance we'd win in front of the ALJ, having lost in front of the district court judge, and then having lost in front of the district court judge and lost in front of the ALJ, winning on appeal. So we started moving to the process where, unless there were significant reasons why the district court judge made a big mistake in terms of not letting in evidence, you know, factual evidence, and not letting in testimony by economists or something like that, we weren't going to do the Part 3 process. I don't know if that's a big change, David, from when you were there.
Yeah, well, certainly that's true. One difference here, by the way, when you move into the non-merger field, is the FTC has the power under Section 13B to go into federal court and seek an injunction or seek disgorgement. And that may be an appropriate thing to do, especially where there's ongoing harm or there has been significant harm in the past. A good example of that brought in the first Bush administration was the case against several infant formula manufacturers for collusion, which, you know, by bringing the case in federal court under Section 13B, they were able to secure settlements with a number of firms, though they ultimately lost that case.
Yes, question.
Hi, I'm Leon Island from UMLEX. I know that the Japan Fair Trade Commission had a system that was very much based on the FTCs in terms of the administrative process, and they just changed it because of procedural fairness issues. I wondered if you guys knew of any other jurisdictions in other parts of the world that have similar procedures to the FTC that have tweaked them in any way based on this issue.
I don't know of any. I know that procedural fairness has been a pillar of what ICN has been working on. And also I know that it's quite often discussed at the OECD meetings. So it doesn't surprise me that that there have been some movement away from our system, and that others have realized that there are other, you know, there's other mechanisms that maybe can work, but I don't know of any in particular.
I don't either, but I think it's you know, that instance and maybe others would be interesting empirical experiments to run. I think this is an issue that it's tough to test empirically, and so maybe that'll provide some opportunities.
Any further questions? I'm sorry.
Let me just make it just sort of general observation that sort of ties into something that Rob said. You know, the commission should be willing to lose. You know, I think too often agencies sort of see themselves as needing to have Lance Armstrong type of records, you know, to really justify themselves, and they want to go and say, we won. You know, you look at the willingness in past administrations to bring the tough cases and lose, and sometimes by losing, you're really helping to illuminate the law or setting other guideposts. You know, and if it means saying that you're wrong in a decision, which the commission used to do before the 1990s all the time, wrong in bringing an administrative case, they should be willing to do that.
With that, we shall bring our proceedings to a close. I want to thank all of our participants and our attendees as well. And David, thank you for kicking this off last August with your paper and sticking with us up to now to end up doing it. Thank you.
Thank you.